Hi, Ben Darby here from Darby and Darby Solicitors, and welcome to my vlog on drink driving and the Christmas risk. Devon and Cornwall Police, where I'm based, have in the last week launched their usual Christmas campaign to warn people about drink and, in fact, drug driving over this period. And given the amount of inquiries I'm receiving at this moment, it's clear that they are already cracking down. The question I'm often asked, would you believe, by people about drink driving is how do I get away with drink driving? It would surprise you that I get asked that often. It does happen. The answer I give every time is do one or the other. Don't do both. It's very simple. If you're drinking, you're not driving, and if you're driving, you're not drinking. That's the message. That's a very simple message. But the purpose of this session is to give you a little bit of guidance, not advice, a little bit of an idea of how the drink driving laws work in this country. That's England and Wales, and for you to be a little bit informed before you make your decisions over this Christmas period. The point I want to raise as well is we've got a COVID Christmas this year, and it's quite likely, in my view, that people won't be obviously in their normal habits of using pubs and restaurants over the Christmas period, but you might be, particularly over that 5 days of Christmas, be in each other's houses, and there may be more temptation to drive where you're going to people's homes where there might not be public transport around. So please take all this into mind and what I say on this session when considering making your choices over the Christmas season. The law, England and Wales, the law is relatively straightforward in my opinion. There are some quirks to it, but it's relatively straightforward. Everyone knows this. Drink driving is illegal, plain and simple. If you're over the limit and you're driving a motorised vehicle, then you are going to find yourself falling foul of the drink drive rules and laws. The other offences to think of, there are other offences like drunk in charge. Now this is where you are drunk but in control or responsible for a vehicle, but not driving. So police may find you asleep at a wheel in the car. No one's seen you driving, so you cannot be done for drink driving. But you can be slumped with even, with your keys in your pocket or the engine's running to keep you warm. The key with this is drunk in charge is you could find yourself being found guilty of that just by being in control of the vehicle. What is quite important for this, we all know innocent until proven guilty. In this country, if you're accused of something, then you are required to prove, the prosecution is required to prove that you're guilty of the offence you're accused of. There are some times where that burden of proof, as we call it, so the responsibility of proving your innocence switches. Drunken charge is one of them. If you are charged with drunken charge, the onus is on you, the responsibility is on you to prove to the court that you were not planning to drive. So easiest way to prove that is actually, look, I'm waiting for my taxi to arrive, and you've got proof of the phone call, the text message, or the taxi booking, whatever it is. But the responsibility is on you to prove that you were not going to drive when you're sat in a car drunk or otherwise responsible for that vehicle whilst intoxicated. Other thing to bear in mind is these laws don't necessarily just apply to motorised vehicles. The classic drink driving does, the one where you get banned from driving in the future, but certainly in my experience I've also dealt with somebody who's been prosecuted for being drunk on a bicycle on a highway. The limit, 35 in breath. I'm not going to touch on samples in urine, samples on blood in this session, but 35 in breath. Do not try and calculate how many units or how many pints 35 in breath is. The reality is there's too many other factors playing into that calculation to show whether you will be under or over that limit of 35 in breath. Factors like, have you been drinking the day before? How much sleep you've had? How heavy you are? Factors like how much you've eaten during that day, the length of time over which you've been drinking, and the length of time since you stopped drinking. It's far simpler not to drink and drive than trying to do little calculations in your head about whether you would or wouldn't be over the limit. I know cases where people sat next to each other could drink exactly the same, and one would be under the limit and one would be over the limit. So do not try to do the science, do not try to do the mathematics on it. Also on this point, think of next day risk as well. If you've had a skinful of booze the night before, you've got to really give yourself time for that alcohol to get out of your system before you get behind the wheel of a car. I've also had people who've had a good lunch, done the right thing, left their car behind, gone back in the evening to get it, but haven't left it long enough. Please take responsibility and try not to calculate what period you think is right. Other factors that come up is public highway. You know, you are guilty of drink driving if you are over the limit driving a motorised vehicle on a public highway. Now, people just assume public highway just means a road, an A road, a B road, a motorway, whatever it is. The definition in the law is wider than that. It's anywhere where the public have effectively the right to go in their vehicles. People can be prosecuted for drink driving in pub car parks. Pub car parks are private land. Many car parks in this country are private land, but the public generally have access to drive their vehicles on it. You will be potentially found guilty of drink driving in a pub car park, even if you're just moving your car around. Sentencing. Drink driving, mandatory ban. If you're found guilty of drink driving, so it's driving whilst over the limit, excess alcohol, you must be banned by the court. The minimum ban is 12 months. You are likely for the low level offences to receive a fine as well. Once your breath reading gets up above 90, the court will start considering more serious penalties for you. That's community service, unpaid work, probation services, working on alcohol treatment programs, those sort of things. When you get to 120, so 90 is about 2.5 limit, you get to 120 in breath, massive reading by the way, the court would be potentially considering imprisonment for you. Drunk in charge, it's not a mandatory ban, but there's a discretionary ban, so the court would potentially look into disqualify you from driving depending on the circumstances of your case. The other thing to bear in mind is if you've been done for drink driving before, if you pick up a second drink driving offence in 10 years, minimum ban is 3 years. And obviously the other penalties like fines or community service will follow. Other factors taken into account, if an accident occurs or someone's injured because of your driving or there's damage to property, that makes your offence more serious. So those factors are all taken into account by the court. Defences. Now, apart from the obvious evidential defence, I wasn't driving or I wasn't drunk, there's a very limited amount of defences available to you. Another defence potentially available to you is what people affectionately call the hip flask defence. That means when someone, when the police attend a scene and find your vehicle and it's, let's say, crashed, but you've been drinking after you're driving. So think what the prosecution need to prove. They need to prove that you were over the limit when you were driving. There's nothing illegal about being over the limit when you weren't driving. So sometimes it's called the hip flask defence, or you've had a crash. Somebody has come out and said, "Oh my gosh, have a nip of this, drink this to calm your nerves and steady your nerves," and you've just swigged back a big brandy to calm yourself down. Now, that is a defence because you weren't over the limit when you were driving if it's the brandy that's put you over the limit. But once again, this is quite difficult for you to prove. This is another case where the prosecution don't have to prove you're under the limit because they've got a reading to say you're over the limit. You've got to prove, the onus is back on you, you've got to prove that you're under the limit at the time of driving. That can only be done with some forensic evidence, and that's what we call a back calculation, where full details of what you drank is put towards a forensic scientist, including the drink before you're driving, if any, and the drink after you're driving, and they will compare your reading and see if what you say is correct. And if that's proved, then fantastic. You'll be not guilty of drink driving. It's quite difficult to prove because it has to be quite an exact science about what you drank, when you drank, what weight you were. And these are all factors that scientists take into account, and it gives a window. And most back calculations I have dealt with don't necessarily turn on the scientific evidence, they turn on how provable your evidence is of how much you drank with your dinner before you drove and not the big brandy you had on the roadside afterwards. So quite difficult for you to prove, much easier, if I'm honest, not to get behind the wheel in the first place. Another factor that comes up, not necessarily a defence, is something called special reasons. This is not a defence to drink driving, but it is a reason not to disqualify you. Special reasons, typical one would be shortness of distance. Now, shortness of distance is where you've got behind the wheel of a vehicle and you've moved it just a few yards to get out of the way, maybe for an emergency vehicle or something else where it's causing a risk or a danger to someone else. You would plead to the court, please don't disqualify me. I have a special reason for driving on that occasion because I had no alternative but to drive. The simplest way of describing this test is, if it's a special reason, would your sober friend next to you who couldn't drive advise you to drive that vehicle at that time? If the answer to that is yes, you've got a pretty decent argument for special reasons and not to be disqualified. Doesn't mean you're not guilty of drink driving, but it gives you reasons not to be disqualified. If, however, that sobered friend next to you who's not licensed to drive would have said, actually, no, you don't really need to drive this vehicle, then you're getting disqualified. But that's my summary of drink driving. I think it's appropriate to bring it to everyone's attention this time of year. Drink driving prosecutions and drug driving prosecutions typically increase, so please crack down over the festive period. Please make the right choices, but if you find yourself in a position where you need some advice or guidance, please contact me. Similarly, I'll be doing a Q&A on drink driving this Thursday evening at 6 p.m. here on Facebook. Thank you for listening.